In this topic we're going to cover civil remedies, which is another way of saying the different types of outcomes you can get from going to court. A remedy is a way that a judge will try to right a wrong that has happened in a civil case. The general principle that judges use and the general purpose of remedies is that they will try to restore the plaintiff to the position they were in before the wrong happened. So in other words, if the wrong caused you to lose $5,000, right, the purpose of the remedy is to restore that $5,000 to you. We're going to study two remedies in particular. The first is damages, the second is injunctions, but you'll also need to know, at least generally, what each of these other ones are. For example, specific performance is when the judge makes an order that the defendant has to do something. For example, they have to finish completing a building as per their contract. Damages are when a plaintiff gets money after they win their case. Damages are generally one of the most popular and most common remedies sought during a civil proceeding. The amount of money you're likely to get from damages will depend first of all on how much the plaintiff is actually claiming, and second of all on the jurisdiction of the court. So higher courts generally are able to give out more money in damages. As we can see from this flowchart down here, damages can be divided up into a number of different types, and we're going to explore each of these types in the following slides. The first main type of damages is compensatory damage. This is the most common form of damage that's awarded by the courts, and the purpose of this type of damage is to compensate the plaintiff for any injury or damage that they might have suffered. One thing that you should be aware of is the fact that it's not always possible to exactly compensate someone if they've had some sort of physical loss. So for example, if they have had some accident which has left them without a limb, the court can't give that limb back, but they can give them damages that might make up for losing that limb. So damages that might compensate for the loss of that limb. There are three different types of compensatory damages. Specific damages can be given a precise monetary value. These might be things like medical expenses or loss of wages. They are things that are easily quantifiable and you can give a specific number to. General damages, on the other hand, are things that you can't give a precise monetary value to. So instead, the court will consider the magnitude of the wrong and the long-term consequences of it. And they'll try to consider things like future loss of wages, any impact on your long-term job prospects, and things like pain and suffering. The key thing to know about general damages is that they are usually a general estimate, and the judge can't put a specific and precise number on it. Aggravated damages is used to award the plaintiff with further compensation if the court believes that the defendant's conduct intended to cause humiliation and insult, or caused humiliation and insult to the plaintiff. There are three other types of damages. The first is exemplary damages. This is also known as punitive damages. This type of damages is used when the court intends to make an example of the defendant to the rest of the community. In this sort of case, the defendant will be ordered to pay a large amount of money either to punish them or to try and deter others in the community from acting in the same sort of way. Nominal damages, on the other hand, is when the defendant only has to pay a nominal, or in other words, a very small amount of money to the plaintiff. This sort of damages might be appropriate when the plaintiff hasn't suffered any sort of significant injury or loss, but they're litigating more about the principle of the matter. So for the plaintiff, the fact that the judge has said that they are in the right is more important to them than the amount of money they get in damages. And finally, there's contemptuous damages. With contemptuous damages, a court might feel that even though the plaintiff has technically proven their legal right and they have technically won the case, they might not necessarily deserve morally to get paid much money. In this sort of a case, a small amount of money in damages might be awarded to show contempt for the claim by the plaintiff, even though the court is admitting that they are legally right. The general purpose of all remedies, damages included, is to restore the plaintiff to the position they were in before the wrong occurred. Some additional purposes of damages include some of these following: to compensate the plaintiff for any losses that they might have suffered, such as through medical expenses, for the plaintiff to make a point about being legally right, and this is where a judge might allow for nominal damages, or to show contempt for the claim that is made, and this might occur with contemptuous damages. Finally, another purpose of damages might be to punish the defendant for an extreme infringement of rights. Now that we've explored what some of the purposes of damages are, we want to think about whether or not damages actually achieve these purposes. So some of the factors we might consider when thinking about this include some of the following. The first and probably most important one you want to think about is the plaintiff's injury something that money can actually fix? So if we were to return to the example of someone who has lost a limb, even though the purpose of damages that a judge awards might be to compensate that victim, money doesn't really replace that limb, which means damages can't really fully achieve their compensatory purpose in that scenario. Another factor to consider is the type of loss that the plaintiff has suffered. Monetary damages, for example, are very good at compensating for economic losses, but physical, emotional, and mental losses, well, money often can't really fix them. Another factor that often makes it difficult for judges to calculate damages is considering whether or what the appropriate measures are for unquantifiable losses, for things such as pain and suffering, or humiliation, or the loss of life or a loved one. In each of these scenarios, it's very difficult for a judge to weigh up and put a specific number on the loss that has occurred, which makes it significantly harder for the judge to accurately achieve the compensatory purpose of damages. Another factor to consider is whether damages can compensate for the time that the plaintiff has to have hearing the case, and the stress and inconvenience it causes that they have to go to court. Further, if the defendant doesn't have the ability to actually pay you after the court case ends, then you have to question whether damages can actually achieve their purpose there as well. There might also be restrictions in place, such as those in the Wrongs Act, which might limit the amount that you can be compensated. And finally, there might be some other remedy, such as an injunction or an order for specific performance, that might be a better way to compensate the plaintiff. In summary, damages will be an appropriate remedy when the plaintiff has some sort of economic loss, such as the loss of money or wages, or some sort of good that can be replaced by money. Damages is appropriate in these sorts of circumstances because money is capable of restoring the plaintiff to the position they were in prior to the wrong. Damages will not be an appropriate remedy in circumstances where the plaintiff has suffered some sort of loss or injury other than pure economic loss. This might include damage to reputation, loss of physical limbs or a loved one, or some sort of mental impact such as anxiety or illness. In these types of cases, damages cannot restore the plaintiff for these non-economic losses. Further, because the Wrongs Act places restrictions on the amount of damages that can be obtained, in situations where the plaintiff has been extensively damaged, it's possible that they might not be fully compensated. Damages will also be inappropriate if the defendant isn't able to pay the damages. In this case, a court order would be futile, and the plaintiff isn't going to be restored or compensated for anything because they're never going to see that money. Finally, damages do not compensate for the time, inconvenience, stress, and cost of having to go to court. Therefore, the plaintiff will normally have to seek additional orders for costs and interest, and even then, they might not fully compensate them for what they've experienced. The second type of civil remedy we're going to look at is injunctions. An injunction is a court order directing someone to stop doing something or to start doing something. These two types of injunctions are called restrictive injunctions and mandatory injunctions. A restrictive injunction is when the court orders a person to stop doing something. For example, stop demolishing that building, or stop visiting that child at school. Alternatively, a mandatory injunction is when the court orders a person that they have to do a particular act. Usually, this is when the court orders someone to perform one of the clauses of their contract. So, for example, you have to keep building that building like you said you would. Injunctions might also be interlocutory or perpetual. An interlocutory injunction is one that's temporary. It's awarded in urgent circumstances, it's awarded quickly, and will only last a certain amount of time. After the final court hearing, the interlocutory injunction can then become what's known as a perpetual or a permanent injunction. That simply means the injunction is going to keep lasting forever. The general purpose of an injunction is to rectify or to resolve a situation caused by the person in the wrong. But each specific type of injunction has a slightly different purpose. So for example, restrictive injunctions, their purpose is to make someone refrain from doing something. Mandatory injunctions, their purpose is to order someone that they have to do something. And interlocutory injunctions, their purpose is to preserve the position of both parties until the matter is determined by court. So for an example of the interlocutory injunction, you might have a defamation case where somebody is publishing a potentially defamatory article, and the court might order an interlocutory injunction, in which case the article might have to stop being published until the court hears the matter, determines whether or not it's defamation, and then after the case, they'll tell the parties what they have to do about it. At which point, that injunction might get dismissed if it turns out that the defamation, that in fact it wasn't defamation, or the interlocutory injunction might become a permanent injunction. Some of the factors to consider when determining whether or not injunctions are going to be effective are, first of all, will an injunction even return the plaintiff to their original position? So for example, if there's a dispute about the demolition of a house, and the defendant goes ahead and just totally demolishes your house, even if the court orders an injunction and tells them to stop demolishing, that's not going to do anything, right? It's not going to return you to your original position because the house is already gone. In that sort of scenario, damages are probably going to be a more appropriate civil remedy. Other factors that you might want to consider is, will the defendant even comply with the injunction, or will an injunction even be able to stop the defendant from doing something harmful? Or is there some other remedy, such as damages, that might be more appropriate? An injunction can restore a plaintiff to their original position by ordering that the defendant fulfill an obligation, such as, typically, the main example of this is when the court orders a party to perform their part of a contract. Where the actions of the defendant have already caused damage, an injunction will not restore the plaintiff, but at the very least it can try and stop any further damage. Finally, the effectiveness of an injunction might depend on how willing the defendant is to comply with them. Although usually, if the defendant doesn't comply with an injunction, the court might make adverse findings against them, might fine them, for example. One of the skills you need to have for this topic is being able to evaluate how civil procedures can contribute to an effective legal system. Remember, the three elements of the effective legal system that we studied were, first of all, fairness, second of all, timeliness, and third of all, ability for people to access the legal system. The first element of an effective legal system that we're going to analyse is having a fair and unbiased hearing. On this slide, we're going to look at the different processes and procedures that can contribute and that can hinder a fair and unbiased hearing. Pleadings, for example, can enable the parties to become aware of the claims, defences, and counterclaims that are being made in the proceedings, and this can afford them natural justice and procedural fairness. It ensures that the parties are prepared for the case, and that the trial proceeds on the basis that the parties have made all the possible claims that they can in their pleadings. In other words, pleadings ensure that there's a fair and unbiased hearing by making sure that both sides go into the trial as prepared as possible. On the other hand, pleadings can actually hinder a fair and unbiased hearing. For example, pleadings are often so complex that they disadvantage a party who does not have legal representation. Pleadings normally require the expertise and knowledge of a solicitor or barrister, and if you don't have enough money to pay for one, you'll be disadvantaged and you are less likely to have a fair and unbiased hearing. The discovery process can also contribute to a fair and unbiased hearing. Discovery ensures that all parties have access to the same information and the same documents that are relevant for the trial. The parties become aware of each other's evidence, which reduces the element of surprise at trial, and this assists in both parties being on equal footing with respect to the knowledge of documents at the trial. On the other hand, discovery can hinder a fair and unbiased hearing as well. So although discovery is designed to clarify issues in dispute and avoid surprises at trial, the discovery process can often be long and complex, and it requires legal representation. This can disadvantage people, for example poor people, who don't have the resources to hire expert legal representation. Another civil procedure that contributes to a fair and unbiased hearing is the directions hearings. Having both parties present at a directions hearing ensures that a proper opportunity to make any submissions, applications, or arguments to the judge is available for both parties. This allows for a fair and unbiased hearing because all parties have the opportunity to be heard. On the other hand, directions hearings and mediation can hinder a fair and unbiased hearing because a party with more experienced legal representation may argue their case better at a directions hearing, and thus might be better placed to obtain the orders they want in their final case. Further, at mediation, a party without legal representation might feel intimidated by the process or be unable to clearly present their arguments. This might result in an unfair outcome. The second element of an effective legal system that we're going to analyze is access to the legal system. Some of the processes that contribute to effective access include contingency-based legal representation. This is another way of saying no win, no pay, and this sort of process can help people with a genuine claim but little money get their day in court. However, a corresponding weakness to this that could potentially hinder effective access is the fact that courts are so expensive. The cost of lawyers and the cost of going to court can be prohibitive and prevent people taking their issue to court. Pretrial procedures are another way of contributing to effective access to justice. For example, a party will have access to court-ordered mediation, documents discovered by the other side, and the ability to order interrogatories to help assist them with their claim. These procedures can help them to reach an early out-of-court settlement or help them to define the issues that are going to be in dispute during their trial. On the other hand, the complexity of these procedures can hinder effective access to justice. Specifically, pretrial procedures are quite complex, and usually you'll need to hire a lawyer to help you through them. Further, the extensive use of pretrial procedures is often criticized for causing delays in our court system. So the complexity and the delays associated with pretrial procedures can often deter people from going to court in the first place, and this can hinder the access to justice that people have. The final element of an effective legal system we're going to look at is timeliness of dispute resolution. There are a number of processes that can contribute to a timely resolution of disputes. For example, pleadings and discovery can reduce the time needed to resolve a dispute. They provide the parties with the opportunity to find out details about the case being brought against them, and this can result in one party deciding not to pursue a case. Or, alternatively, it could encourage the discussion between parties to lead to an early out-of-court settlement. And even if the matter does proceed to court, the pretrial procedures could reduce the time spent in court. Directions hearings are also an attempt by the courts to speed up the process of getting a matter to trial. They do this by clarifying issues before the trial and helping the parties to become better acquainted with the strengths of each party's case. One process that can hinder the timely resolution of disputes is the fact that recently there's a trend towards increased litigation. The increased number of civil cases being brought before our courts adds to the delays that people can experience. This has occurred at the same time as increases in volume and complexity of information that we have available. Improved technology has provided businesses and individuals with the ability to do far more in terms of gathering information and expanding business opportunities. It has also created a situation where there is likely to be more information to gather and sift through when a case comes to trial. This is particularly troublesome during the discovery period, for example, where you might have an extremely huge amount of documents to discover, which can result in delays in getting a case to court. Finally, pretrial procedures are long and complex, and they can often cause delays in getting a matter to trial. Often, these delays are caused by the parties themselves, who might not understand the procedures and will require adjournments of time in order to figure out what's going on. Particular procedures, such as discovery, also often take a significant amount of time as a result of a large volume of documents. This too can delay the time it takes to hear your matter in court. As we finish this topic, we are going to spend our last slide checking for our understanding of the main areas we covered. By the end of this topic, you should be able to explain Supreme Court civil pretrial procedures, which includes pleadings, discovery, and directions hearings. You should also be able to explain the purpose of each of these procedures. You should be able to describe the different types of civil remedies, and in particular, we focused on damages and injunctions. And finally, you should be able to describe the purpose of those remedies. Normally, you can understand the types of exam questions that might be asked about a topic by looking at the skills that the study design describes. So for example, here we can see that you're required to describe pretrial procedures, but you're also required to be able to compare them to the relative purposes of criminal cases and criminal procedure. That tells you that you're likely, or it's possible, for you to get an exam question on this topic asking you to describe or to compare pretrial procedures of civil versus criminal. You also have to show the skill of discussion, which means you have to be able to talk about essentially both sides, so maybe strengths and weaknesses of civil remedies in terms of whether or not they can achieve their purposes.